So there's a little argument right there about how this line of questioning is going. Joining me right now is trial attorney Andrew Cherkasky, as well as forensic psychiatrist Dr. Carol Lieberman. Andrew, let me ask you, the defense is raising interesting arguments, and one of the things that they keep saying is that this surveillance footage, these cameras that they installed, it wasn't necessary. They could have shown that prostitution was going on. They could have, there was enough evidence of that they didn't need these cameras installed. And that's one of the arguments that they're saying, that this footage should be thrown out. Is that a valid argument?
Well, there is some precedent for the idea that the need to put video cameras has to be an exceptional need, essentially, that it's something that has a heightened requirement before they start putting it, especially in places where there's some degree of privacy interest. They're trying everything they can. I mean, they are using every play in the playbook. We see them just now fighting about whether certain evidence is going to be even considered on the question of whether the legal issue is satisfied or not. That's something that I do quite often. There's a debate with the judge about what he's going to even consider on the legal issue as to what he's going to allow the jury to ultimately see. So we are deep in the weeds right now.
Do you think that he's going to make a decision on this today about whether or not this footage will be allowed into trial?
I don't know if it's going to be today. I mean, we certainly have a lot of forward progress this week. We have him making a decision about the release of the video to the public. So I think that it looks like things are certainly moving along.
Yeah, I think he hopes to conclude this hearing by noon, but judging the way these back and forth is going, that might not be the case. I think we have an opportunity to jump back live into court. So let's do that. We can listen to more what's happening. Okay, so Andrew, where is his defense attorney going with this line of questioning? We heard a little bit last week how the idea was that, you can't have these undercover agents going to this spa because there's a danger to them that they might be touched, that they might have to get naked, and they'll actually be doing something illegal in order to be investigating illegal conduct. Is that what this line of questioning is about, or where do you see it?
Well, I see it more along the line of the necessity to have placed the cameras where they placed the cameras. See, the defense's argument centers around the idea that because there should have been an expectation of privacy in these booths because people get naked, that there should be this heightened degree of probable cause necessary, or this necessity required for the cameras to be planted, as opposed to going about different investigative efforts that wouldn't require filming someone in the nude or filming someone in this private situation. So they're going down this path with the detective of, you could have done all of these other things to get these investigative leads. Now, I think this attorney is spinning his wheels a bit, and it looks like he's a little out of control in handling of the witness. I think he's trying to make points that are already in the document. Maybe he's putting on a bit more of a show than is making sense for his case right now.
That may be. I mean, he's been questioning for a long time, including on Friday. Now, Andrew, this is getting a bit testy with his defense attorney, prosecution, the judge. What is going on right now? What should we be making of this?
So we've got a witness on the stand who is called by the defense. The defense goes through a series of their questions. Then it's handed over for cross-examination by the prosecution. Even though it's ultimately a prosecution witness for the purposes of this motion, the prosecution then cross-examines. Then the defense gets to redirect, so they get another chance, and they're really kept to the four corners of what the cross-examination was about. That's this idea of what's the scope of redirect examination has to be with regard to something that happened on cross. So that's what they're fighting. I mean, they're fighting about what questions he should be allowed to ask at this point. We're not even talking about the substance of things anymore. So they are deep into it. It is very aggressive. We see this all the time in courtrooms, but this is the stuff that goes on outside the presence of the jury.
Yeah, it really is. It's interesting to watch, especially given this case. Well, as we watch Alex Spiro, who's representing Robert Kraft, grilling this lead investigator, one thing to note, he's also been hired by Jay-Z to represent 21 Savage in his deportation case, so he's quite a prominent trial attorney. Andrew, I got to ask you, the idea here about what police did and what Robert Kraft's rights are, what is Robert Kraft's rights exactly? His constitutional right to privacy in a spa like this?
Well, that's part of the debate here. The right to privacy typically it would require a warrant before you're going to have that broken into. The idea of a warrant is that there's probable cause to believe that there's criminal activity, and that the actual search will result in some sort of evidence of that. Now, there's all sorts of legal nuances to that. What the argument here is that the scope of the warrant was unnecessary given the idea of what they were trying to capture. So they're going into an area of privacy in order to capture potentially illegal activity. But what we're hearing now are some really important points. So there was a lot going on before. This attorney has finally gotten to something that really potentially matters. And what they're getting to is this idea that the detectives now are the ones in control of what is and isn't being watched. So they've got this boxer, no boxer rule. I'll skip over how ridiculous that is. But what that shows is that the warrant isn't really as legitimate because it's the detectives who are really making the decision about who they should watch and who they shouldn't watch, where there's a warrant that's so broad that would allow them to watch anybody without regard to whether or not there is some sort of reasonable basis there to believe that there's criminal activity. So there's some points being scored here.
They make enough good legal arguments. Imagine if they could get this tape thrown out. Where would that leave the state's case? All right, let's break down some of this case right now. Joining me back is trial attorney Andrew Cherkasky. Andrew, I got to ask you, if they are successful in getting this tape thrown out, where does that leave the prosecution's case against Robert Kraft?
I think at that point the case is done. They really need that video. Now, if the judge is going to allow certain testimony about what the officers witnessed through the videos, but not the videos themselves, perhaps then they have a case. There is that idea that sometimes the judge isn't going to be willing to show the actual evidence, but the fact that the police were monitoring it would be allowed. I think that if the video is gone in this case, the case is done.
Let me ask you this, okay? If the judge ultimately rules that the video can be allowed into trial, they seat a jury, trial's underway. The way I understood it is that he has temporarily halted the release of the video until trial starts, which means if this video goes forward, if the video is not thrown out and a trial starts, that's when we all will be able to see this video? Or what happens if he takes a guilty plea? Would the video still come out?
So what the compelling argument was for the judge in withholding the release of the video, and we have to note that in Florida there's broad rights to have basically anything that's in public hands. So evidence in trials typically is something that would be released. But what was convincing to the judge here is that it might taint the jury pool. So as soon as that concern is resolved, now we get back to the idea of what the Florida law is, and it will be released. I think it's going to be released the judge's ruling said something to this effect. So if the case is dismissed, if a guilty plea is taken, as long as there's not a concern about the jury being tainted, I think the judge is going to release this.
Oof, well, that would be...
That's at least what it looked like in his ruling.
And then it would just be a question of who's going to watch it. Everybody. I know everybody would probably watch this for all different kinds of reasons. All right, so again, that was Herzog from, or I think it was from yesterday, but it was a really interesting development. I just want to confirm that we can jump back into court. We're waiting for the next witness to take the stand. Do we have our feed ready on that? Not ready yet? Okay, so we're going to wait on that. Let me just, if I can, I want to ask one quick question from Andrew. The arguments made by the state here that this was proper surveillance. They have the right to get those, get those cameras in there, even with a bomb scare, a fake false pretense, saying there's a bomb scare, clear everybody out, get the cameras in. That's legal, right?
It is. There are some troubling realities that I think are being exposed here to the extent that some of the search abilities of law enforcement go. I mean, that's coming from me as a criminal defense attorney at this point. I think when I was a prosecutor, my perspective was a little bit different. But yes, there are broad rights. There's also something that they're focusing in on, which is called the good faith exception. The Supreme Court has essentially said that where law enforcement is operating with good faith, that the search authorization, the warrant that was granted by a judge, when they're operating on the good faith that it was all legitimate, that even if it wasn't legitimate, they can still pursue and use that evidence. So there is a lot stacked against the defense here, and the prosecution has quite a few arguments. The defense are making some points, though.
Yeah, this back and forth is something to watch.
It is.
Now, this line of testimony, this line of questioning, Andrew, is something to note because they pull over Robert Kraft, but they don't arrest him. He even at one point flashes his Super Bowl ring to the officer. What do you make of this in relation to the overall case?
Well, what they were trying to do was establish some degree of identity of the individual to continue some sort of tracking or tracing of the individual. So, I don't know why they didn't do the arrest then. I guess they were trying to bolster the amount of evidence they had to see if he'd come back, to see if he'd do it again. I'm not exactly positive what that strategy was versus the original arrest, other than to make sure they had a couple of incidents before they made such an arrest.
Let me ask you this. If this tape does make it in, does the defense have any argument here? I mean, would they have to say, hey, listen, it's pretty clear that our client's on the tape, but where on the tape does it show an exchange of money? Because wouldn't it be legal for him to be in a consensual sex act with somebody at this spa as long as there was no exchange of money?
Yeah, that's certainly very true. I mean, the idea of what he's paying for is a big question. From the day this case came out, I've been referring to it as a Seinfeld episode where Jerry Seinfeld has a house cleaner, and she cleans the house and he pays him, but then he starts dating her. And after a while, he's confused whether he's paying her for dating him and the sex that goes along with it, or if he's paying her for cleaning the house. That sort of analogy can be drawn to this. He's going in, he's paying for a massage, and there's a relationship that consensually forms, and he's not actually paying for the sex act. So there is a legitimate question there.
Right, it's not a slam dunk. So they could first say, even if the tape comes in, I don't even know the quality of the tape. It might be even hard to say definitively that's Robert Kraft. It kind of echoes what we saw in the R. Kelly case so many years ago. But even if they concede the fact that that's him, how do you know it's just not a consensual relationship? And that's a different question. Now, Andrew, here's the thing. We understood where they were going at the beginning of the day, really attacking the warrant and how they got these secret cameras in there. What are you trying to argue about this officer who pulled over Robert Kraft?
I'm not sure at this point, actually. It is deep in the weeds right now. So they're going through every single step of the whys and hows and the radio going back and forth in the efforts to identify the person that was in the establishment, and then to make the actual pullover so that they could identify the individual. So they're going through every step here to make sure that it is according to the very specific nuances of the law that they're arguing. I don't find this to be particularly compelling. If I was the judge, I would be fed up at this point. They're way into it at this time.
But the judge seems to be giving his defense attorneys a lot of leeway throughout this line of questioning of this witness and the other witness. Am I looking at the right way? But then again, isn't this their opportunity to question these witnesses?
Right. So the only thing that's really prejudiced by giving them time is the time itself. So the judge's lack of patience for it. There's no jury that we're concerned that they're receiving some information that they shouldn't be receiving. We're not wasting the time of the jury themselves, something that could try on their patience and hurt one side or the other. So judges do tend to demonstrate their patience and their fairness, or at least the appearance of fairness, in allowing attorneys to go ahead and build the record, as we call it, meaning that they're putting all of this out there so that if there's a complaint later on, the complaint can't be, oh, we weren't allowed to present this evidence. So the idea of a judicious judge who gives great latitude to the attorneys to present that which they want when it's outside the jury, that happens pretty frequently.
Well, I'll tell you what, I think the judge wanted to wrap this up by noon. It's 11:41. Don't think that's going to happen, but we will see what's going to happen more in this case. It's definitely a fascinating one to follow. Well, now things are starting to take a different turn. Andrew, if I'm understanding this correctly, is he trying to suggest that the officer did not have legal probable cause to pull Kraft over? Because if that probable cause came from that surveillance footage, it's kind of like the fruit of the poisonous tree, and he needed independent probable cause?
That's what we're getting at right now, is this idea of the pullover as this ruse to get identification. Was that a legitimate pullover? Was there a requirement, or did they have a belief that they actually needed an independent basis of probable cause? If they felt that they needed that independent basis, then we're further down this road of a question of whether they're actually being legitimate, or if they're telling the truth about the fact that there was some other sort of violation in order to effectuate the ruse to get the identification.
Let me ask you this. I'm sorry. I just want to make sure I understand this. Does this mean, remember, the jury's not here. It's all about what can be admitted into evidence. If this was an improper stop and an improper surveillance footage, could they get evidence of the surveillance footage tossed out and evidence of the stop tossed out, which means now the prosecution can't even show the video of him engaging in the sex act or him leaving the spa?
So if I understand the defense's argument correctly, and there's a lot of filings on paper that go into this, but if I understand the argument correctly, that even if the video from the spa itself was legitimate, but they didn't have the identification of Mr. Kraft because the pullover and the capturing of his ID in that instance was improper, that could then the video thereafter of him, establishing that it is connected to him, that would be fruit of the poisonous tree. That's a lot of leaps to make for the judge, but I think that's the angle that they're going at.
How inclined is the judge to side with the defense right now?
Well, right now, in the state of the law with regard to Fourth Amendment and searches, the Supreme Court has signaled to the courts in trial settings like this that as long as law enforcement is acting in good faith, that the results of their searches should be allowed. So there's a huge swing at the moment that is prosecutorial, that's in favor of the prosecution being able to present evidence. So I would say that the judge is very reluctant to grant in a legal search. I don't win a lot these days. Sometimes I win them on appeal, actually, but that's what they're trying to do. They're doing everything they can to secure the record because we're not in a great state of law right now from a defense perspective.
And 30 seconds, just real quick, whatever is decided about this video, do you think it's going to be the conclusion of this case, or do you think either the prosecution or the defense is going to move forward?
No, I think the defense would move forward if the video comes in. There is that defense that we were talking about earlier. What's he exactly paying for? I think that's a very valid defense. I think a jury could be very sympathetic. I think we've seen a lot of people in the public sympathetic to Mr. Kraft going through this. So I don't think the defense wraps it up or goes to a guilty plea just because they lose this motion.
But it would change the whole tone of the case moving forward. Andrew Cherkasky, thanks so much for coming on. Appreciate your insight as always. I am going to be signing off, but Misty Maris is coming in, and she's going to guide everybody through the next chapter of the Robert Kraft hearing. We'll be right back.